Recording. Good morning. My name is Becki Young. I'm a partner with Grossman, Young and Hammond in the Washington, D.C. area. And I have with me Mary Pivec, an employer compliance attorney who is of counsel to our firm. We're so glad that you're here with us today to talk about employer compliance. Lots of exciting developments on that front. We have today's webinar is co-sponsored by the Restaurant Association of Metropolitan Washington. And we do have quite a few hospitality industry individuals on the call. So we'll definitely be talking about employer compliance that impacts the hospitality industry, but also many other industries as well. So we have a presentation to share with you. We're going to talk, and if you have questions, you can put them in the chat. I will do my best to integrate them into this conversation. We'll also try to save a little bit at the end for questions. So let's go ahead and get started with our presentation. Okay, so Monday is going to be a big day in Washington, D.C. We have a transition of administrations and a lot of developments expected, which is why we decided to sponsor this webinar today. With me is Mary Pivec, and here's some information about Mary. I wanted to ask Mary to briefly introduce herself specifically with regard to her employer compliance experience. She has really one of the most impressive biographies, resumes in the country with regard to employer compliance. So Mary, do you want to just set the stage by providing a little background about your employer compliance experience?
Thanks so much, Becki. Yes, I'm a workplace lawyer. I've spent my whole career representing employers deal with the laws and regulations governing the workplace and their dealings with the government and their employees. My career spans the entire length of the employer sanctions program, which was instituted by Congress in 1986. And over the course of my career, I estimate that I have represented employers in well over 100 I-9 audits and many anti-discrimination related claims under the Immigration Reform and Control Act. I'm so pleased to have joined your firm, to have joined forces with you and with the fine lawyers at Grossman, Young and Hammond, who will be working together to help employers deal with the challenges of Trump 2.0 and his plans for a rigorous immigration enforcement program in the workplace.
We're so pleased to have you, Mary. So let us, goodness. Oh, Christina, I might have to ask you to share the slides because mine seem to be stuck. And we just, oh, here we go. Okay, so the first question we have for you, Mary, is what is the most recent indication of the incoming administration's intent to implement a massive uptick in I-9 audits? And maybe, I think most people on this call know what an I-9 audit is, but maybe as a preliminary matter for those who don't, if you could just explain what that is.
Well, an I-9 audit is conducted by the Immigration and Customs Enforcement branch of DHS. They have hundreds of forensic auditors now who do that, although agents generally come to the work site in order to collect the documents and other materials that would be used in the forensic I-9 audit. Most employers have not experienced an audit in many years. During the first Trump administration, there were aggressive plans to conduct 15,000 to 20,000 audits in fiscal year 2020. That would have launched in September of 2019, but COVID came along. And then Biden was elected. And during the Biden administration, the DHS adopted a policy of not conducting any enforcement or surveillance operations involving immigration enforcement in what are called sensitive areas. And that enveloped almost all urban areas, as well as community centers, hospitals, grocery stores, any place where the immigrant community might go for food, housing, services. So that is going to be taken off the table. We know from the new Border Czar, Tom Homan, that he intends to use the I-9 program or the I-9 audit program to identify undocumented workers and remove them from the workplace. That will be a principal tool in their toolbox. You have put up a slide as to which industries are most vulnerable in our area. Well, we've listed them out here. We know that there is a heavy concentration of undocumented workers and immigrant workers who are documented in the industries that are listed. We know that the restaurant and hospitality industry is well represented in our program today, and they know that they are in the bullseye for potential raids and I-9 audits. In fact, the president-elect has indicated an intent to conduct a really high-profile, massive raid in the DC metropolitan area soon after taking office. And just putting on in my speculation hat, there's a lot of heavy construction going on in and around Northern Virginia. And we'll see if I'm right or not, my guess is that it might be one of those sites that is the target for this large workplace raid that has been predicted.
Thank you, Mary. And I want to pause for a moment. I believe that our friends from the Restaurant Association are with us. Sean, if you're here, can you unmute yourself and say a quick hello? Okay, maybe not yet. I thought I saw that they joined. So if they do join us, we will give them a minute to say hi. But for now, let's move ahead. So what are our top recommendations for employers in the targeted industries? And I do want to mention the slide said in our area, we're in the Washington, D.C. area, but I think those industries, correct me if I'm wrong, are targeted across the country. I mean, those are the industries that are really most vulnerable.
Yes, absolutely. Absolutely.
Okay, very good.
Are we ready to proceed?
Yes, please.
Okay. Over the course of my career, most of the time I have been called on to assist an employer after a notice of inspection has been served or after a raid has gone down. Of course, a lot can happen when the employer is unrepresented. Frequently, they're not prepared to deal with agents who are carrying guns, and they are nervous, and they say things that they should not say, which can and will be used against them in proceedings down the line. So my first representation to any client or any potential client who feels that they may be targeted in this Trump administration, engage counsel before a raid occurs, before an I-9 audit occurs, to assist you in developing an effective raid action plan, provide staff response training, and advise on immigration status and document review issues as you conduct your internal audit. The number 2 on the list is to conduct that audit in advance of a notice of inspection being served. You want to be able to identify and correct errors and omissions to ensure readiness for production on a 3-day notice. Third, and this is the saddest part. This is the saddest part for any employer. If you do the I-9 audit properly and you identify individuals who cannot or will not provide you with the documents that are necessary in order to properly verify their identity and employment eligibility, I strongly advise that those employees be suspended or terminated until such time as they are able to do so.
Great. Okay, moving along, we have our next conversation is about ICE. So when you are going to be subject to an I-9 audit, how is ICE going to let you know about that?
Generally speaking, in the absence of a situation of a raid where there is going to be a warrant involved, and we'll be talking about that later. For most employers, they learn that they're under an I-9 audit when they receive a letter entitled Notice of Inspection. That is required by law. It gives the employee, it can be served in person, and many times in the past, agents came to the business and served the employer with the written notice of intent to audit the I-9s, which has to be signed by an employer representative. The other way that has been authorized by regulation is to do it by certified mail. Many times this is troublesome because employers do not, the right people do not know that they are the target of an audit because the mail doesn't reach their desk. So people have to be alerted to look for this certified mail. That is called the Notice of Inspection.
Hey, so before you get a notice of inspection, probably a good idea to think about an internal audit. And that's something that employers can be doing right now. Mary, what are the steps that you would recommend to employers if they want to be proactive to conduct an internal audit?
Well, first and foremost, make sure that you have access to the DHS I-9 Employer Handbook. It is now online. It runs for almost 70 to 80 pages in hard copy, but it is much easier to use the online version now because there are links to different sections that you can toggle back and forth as you are conducting your review. I would also recommend that you carefully review the joint guidance published by DHS and DOJ for how to conduct an internal audit and avoid discrimination. If you would like a copy of that document, we'd be happy to send it to you. Just be sure to request it in the chat box and we will follow up. When you are reviewing the I-9s, items 2 through 9 are very important. What we have done here is to identify the areas of substantive violation. That is, the errors which can result in fines if you do not do them correctly or you do not correct errors that have occurred in the past. You want to make sure that the employee has completed fully Section 1 of the I-9, and most importantly, that they have designated their immigration status and have signed the attestation, which is the last line of Section 1. If a translator has assisted the employee, make sure that that translator completes the translator preparer section, which is now a supplement to the current I-9 form. Now, next, number 4, make sure that the document verification portion of the I-9 has been properly completed. If you do not know how to do that, do refer to the employer handbook so that you can put the right information in the right spaces. Number 5, make sure that the employer representative who reviewed the documents in the presence of the employee has signed the attestation at the bottom of Section 2. If the employer does not do that, it is as if the I-9 was not done at all, at least in the view of the law. Number 7, if the employee has presented a time-limited DHS employment authorization document in Section 1, and that has expired, is expiring in a future date, it is important to complete the re-verification section in 3. And that will be very, very important for the population of DACA, DHS, work authorization holders, and temporary protected status individuals. Number 8, employers sometimes who have signed up for E-Verify after they did the original I-9 may be tempted to use the E-Verify process to just run that information through for current employees. That violates the memorandum of understanding between you and the government for the use of the E-Verify process and is a discrimination violation. So do not do that. Number 9, if you are using an electronic I-9 vendor, contact them before a notice of inspection is served upon you to make sure that they are ready, willing, and able to produce that file in compliance with the electronic I-9 regulations that DHS has, and that they can produce them within 3 days, because that's the only amount of time that you have in order to respond to a notice of inspection.
Thank you, Mary. And I wanted to let you know, we've got a few questions in the chat about the slides. We will be providing a copy of the slides as well. Mary, you had told people to indicate in the chat if they want the I-9 documents. We'll just send those out to everybody after the presentation along with the slides. So no need to tell us individually. We'll send the slides and those I-9 documents to everybody. There's a new rule about extension of employment authorization documents. So as you may know, an employment authorization document is that sort of driver's license sized card that many non-immigrant workers have that allows them to work in the US. So there was a new rule that gave a 540-day automatic extension to certain people with EADs. Can you tell us about that, Mary?
Yes, I can. Now, there's been a flurry of activity at DHS in the last 3 weeks. The first was a notice to extend the EAD period for up to 540 days. And for everyone except for temporary status employees, this will allow them, provided they can provide the employer with evidence that they filed an extension application prior to the expiration date of their current EAD card, up to 540 days from the expiration date. This is, we have put into the slide the link for the eligibility categories and document verification requirements for the automatic extension, and I would encourage everyone to consult that regularly to make sure that they know the categories of individuals who qualify and periods for which they are qualified. The most difficult part of this rule applies to temporary protected status individuals. These are individuals who are from one of 16 countries who have been designated for protection in the United States and employment authorization based upon war in their home countries or environmental or economic conditions, which the United States deems to be in the best interest to let those people remain in the United States. Their EADs contain the categories A12 and C19. Their status, their country status terminates at varying dates. DHS recently extended the designations for countries that like Salvador, Haiti, Honduras, Nicaragua, Sudan, Nepal, Ukraine. I'm not going to list all 16, but their designation dates vary depending upon the country, and the work authorization extension period varies based on the country. Do consult that link to find out exactly what period of employment they have extended to and how you should annotate the I-9 to reflect that.
Okay. Now let's talk about, we talked a little bit about an internal audit, but I guess maybe some people may be asking, why do I have to waste my time doing an audit and correcting my I-9s before I get audited? Can't I just do it after I get audited?
Well, those were the old days, folks. The law has moved on, and the position of the government is that if you make a correction after you're served with a notice of inspection, you still have a violation. The violation exists as of the date that the notice is served. So don't put off the audit and correction process. The time invested before ICE pays a visit and could save you thousands of dollars in potential fines and penalties.
And we are ultimately going to get to that. I think that, oh, here we go. Speaking of fines and penalties. So this is one of the questions that I get most often. And I asked Mary to really drill down into this because of the extent of her experience with I-9 audit. I think she has a really good real world sense, at least in the past, of what past governments and administrations have done in the real world in terms of fines. So this slide tells you what the possible fines are, but I'm hoping, Mary, that in addition to explaining these possible fines, you can give us maybe some examples about what might happen in the real world depending on the facts.
Of course. Thank you, Becki. Well, there are two categories of violations: paperwork violations and knowing employment violations. In the paperwork violations, by the way, these fine figures that we have listed are the most recent ones that have been updated in response to the Inflation Act, the Inflation Adjustment Act that was passed in 2015. In the old days, fines for paperwork started at $100 and then progressed up to $1,000. Well, those were the old days. The current range is $288 to $28.61 per violation, meaning per I-9 that has a substantive violation in it. The way the government deals with these, supposedly to avoid trying to be fair to everybody, they look at the percentage of I-9s that contain substantive violations. So let's say you have an audit involving 100 I-9 files. These can be a combination of active employees and terminated employees within the retention period. Let us suppose that 10 of those I-9s are defective in Section 1 because the employee has either not signed it or has failed to check off what his immigration status is. And then there are another 10 I-9s where Section 2 has not been completed or signed by the representative. And another 10 where the EAD has expired, but the re-verification section has not been completed. Let's say there are another 10 I-9s that are missing entirely, and another 10 I-9s where Section 2 has been properly completed, but the documents that the employer accepted were not on the list of acceptable documents. I can't tell you how many times employers have put in a foreign passport or a foreign EAD identity document as evidence of a list A document, meaning identity and work eligibility. Well, now we have a file where 50% of the overall inventory contains substantive violations. And in addition, some of those substantive violations involve the employment of unauthorized workers. So what could the fine amount be for them? Well, I worked it up for 50% with 100 I-9 files with some of these violations that I have just detailed. Absent significant mitigation factors, the employer is likely to be assessed a fine in the range of $180,000 to $200,000. That is significant money.
That is significant money. Mary, we have a question, and I think that we are going to get to this, but this is actually something that's confusing even to me sometimes, and so it probably bears repeating. How far back can the I-9 audit go? How long are employers required to keep their I-9 documents?
Well, first of all, for the active employees, for the entire length of employment. For those who have been terminated, if they were employed for less than 3 years, then it goes back to the date of their hire. And for those who were employed for more than 3 years, it is 1 year past their termination date. So employers should be keeping track of their retention obligations on an ongoing basis. They don't want to be producing I-9s that are old because they could expose themselves to fines. If you give up to the government a document which contains substantive errors, even though the employee has been gone for more than a year or more than the 3-year retention period, you'll be fined. There is no statute of limitations on how far they can go back, except in very limited circumstances for violations of the 3-day rule. But we're not even going to get into that today. Make sure that you cull your files to eliminate I-9s that you don't need to keep, but do keep all those that you are required to have.
Okay, and we have a future slide that talks about that, so we will say that again. I'm also going to share with you after this presentation, there's a tool on the USCIS website where you can plug in like the date of hire, the date of termination, and it will tell you when you can destroy the I-9. So we promise we'll give you more information on that topic, because I think that's a very, very confusing, and it's really important, especially now, to destroy your I-9s when you're allowed to do so, because you don't want to be audited and to get fined for non-compliant I-9s that you weren't required to keep in the first place. So we will touch on that again, I promise. Well, here we go. How far back does an employer have to go in reviewing its I-9 inventory? So Mary, someone actually asked in the chat if you could say it one more time. So could you please repeat, how long do you have to keep the I-9s?
All right. For those employed less than 3 years, you have to, you would have to, you have to keep them for less than 3 years. It's from their date of hire. Okay. If it's, obviously that would be less than 3 years in most cases, but so it's from the date of hire. For those who have been employed for more than 3 years, it is the up until the anniversary date of their date of termination.
And for current employees, it's their entire, so if you have somebody who's with you from the 80s, you have to keep that person's I-9. I think that's sometimes a point of confusion. People think it's 3 years, but that's only for former employees. For current employees, you have to keep it no matter how long they've been there, right?
Well, yes, but there are certain employees who are grandfathered. If they were hired and continuously employed prior to November 1986, they are grandfathered. You cannot be fined for I-9s relating to them. That doesn't mean the government will not attempt to arrest them and remove them from the workforce, but you will not be fined for an I-9 violation in connection with them.
Perfect. How about E-Verify? We definitely have some E-Verify employers on this call. So maybe if you can start by explaining what is E-Verify. Most of us probably know, but maybe not everybody does. And then if you are an E-Verify employer, do you still have to worry about auditing your I-9 files?
The answer is yes, you do have to worry about it. There is case law holding that many employers just skip the I-9 process entirely if they are enrolled in E-Verify. They collect the information from the I-9, they enter it into the online tool for electronic verification, which is run by a division of Citizenship and Immigration Services, not ICE. Unfortunately, having a completed E-Verify case file, which says that the individual is employment authorized, will not relieve you of a fine for failure to retain the I-9 document itself, either in electronic form or in hard copy form. It is not an affirmative defense to the failure to comply with the paperwork verification requirements of the Act.
Okay, thank you. So here are some tips for avoiding liability. I'm sure that that's on lots of people's minds. What can you suggest with regard to employing liability?
Well, we have have had a very aggressive individual employee rights section at the Justice Department. They are a division of the Civil Rights Division, and they enforce the anti-discrimination provisions of the Immigration Reform and Control Act. These are their recommendations for avoiding liability when you are re-auditing and originally completing your I-9s. Treat everybody equally, regardless of their suspected citizenship or immigration status. Do not vary your I-9 protocols just because you think that an individual is not a U.S. citizen. Pardon me? All right. Allow your employees to choose which documents they want to present from the list of acceptable documents. Don't dictate what they can present. There's Monty Ramirez is on this call, so I saw his post on LinkedIn involving the Tin. I think that the Tin in New York, it's a big restaurant complex with lots of different restaurateurs. That's, I guess, there was some shakeup up there, and emails that went out to employees actually specified which documents they could present, which is a violation of the anti-discrimination rules. Don't do that. Don't refuse to accept the document or refuse to hire someone because his or her document has a future expiration date. If they are currently authorized to work, you cannot refuse to employ them. Don't request specific documents for someone to create an E-Verify case file, or because they received a tentative non-confirmation or no mismatch in the E-Verify process. Don't request someone present an unexpired permanent resident card, because permanent resident cards that is permanent evidence of their work eligibility in the United States. They are granted or they are issued for 10-year periods, but once you have verified an individual who presents such a card, they're good for the duration of employment. And don't request specific documents in the re-verification process. This is the big hang up here. Suppose an employee presents a time-limited work authorization document, and when they come back to you for re-verification, they present an unrestricted Social Security card. Absent knowledge on your part that that card is not good or is fake, it doesn't relate to them, you must accept that Social Security card as evidence of their eligibility to continue working for you for an indefinite period of time. These are just a few of the tips, all of which can be found on the DOJ website for anti-discrimination.
Okay, thank you. So what advice do you have for employers in industries with large numbers of immigrant workers, of course, one of which is the hospitality industry?
Well, I would reiterate the top 3 tips that we gave before. Engage counsel before a government action occurs, either in the form of a raid or a notice of inspection. Do conduct an internal I-9 audit and correct errors. And unfortunately, terminate or suspend workers who cannot present acceptable documentation. Here's the most important thing. If you are raided, the first thing you do is call your lawyer. When ICE arrives at the worksite, call the lawyer immediately. The receptionist or company representative who greets those officers should say, our company policy is to call our lawyer, and I'm doing that right now. Your lawyer may be able to come to the worksite or join via Zoom, as we are doing today, and be physically or virtually present as the raid is occurring.
And that is an important point, Mary. So we work with employers across the country. And so, if you do need help with an audit or a raid, we are able to assist you remotely. We also could refer you if you want someone on the ground. So there are plenty of options. Hopefully this will not happen. But we are here to help if needed, and also can refer you to someone locally. We have a question in the chat. During an audit, will all the employees' I-9s be audited, or will a random selection be made?
My advice is to review all of your I-9s, all of them.
I think the question, though, is if you are audited, are they definitely going to look at all of your I-9s, or could they just ask for some of your I-9s?
No, they look at all of them.
Yeah. Okay. What are immigration agents authorized to do when they visit a worksite?
Well, immigration officers are free to enter any public area of your workplace, but they must have a valid search warrant or your consent to enter non-public areas. That's important. A valid search warrant must be signed and dated by a judge. It will include a time frame within which the search must be conducted, a description of the premises to be searched, and a list of the items to be searched for and seized. For example, payroll records, employee identification documents, I-9 forms, Social Security Administration correspondence. If you have no matched letters in the file, they will seize those as evidence of knowledge that an individual is presented documents that don't relate to them.
And Mary, can you please let everybody know what a no-match letter is?
A no-match letter comes from the Social Security Administration, and in an attempt to rectify their files to ensure that monies deposited into a particular account is going to the right individual or to for future use. If we know that there is a lot of identity theft out there, and that there are some undocumented individuals who have purchased documents, the Social Security numbers relate to other people, not to them, but the counterfeiters have produced a document which uses that Social Security number and which will pass muster through E-Verify for the Social Security check. Social Security has been sending letters to employers and to employees to notify them that some of the numbers which have been submitted along with the FICA contributions do not match up with individuals in their Social Security files. When the employer gets that, they're on notice that they need to contact the employee to notify them of the mismatch and to attempt to resolve that mismatch. Now, the government wants that information because they know that the employer is more sophisticated if they've been put on notice by the Social Security Administration that the Social Security account numbers that their employees have do not match. The agent who serves the warrant, after he's effectively served the warrant on the company representative, will then alert other agents to enter the business. The company can accept the warrant, but not consent to the search. And this is what we recommend that you do, that you accept the warrant, but not consent to the search. This would enable your lawyer to contest the warrant and challenge it down the road if need be. Depending on the type of business, ICE may demand that equipment be shut down and that no one leave the premises without permission. ICE may move employees into a contained area for questioning. While some agents question employees, others will execute the search and seizure of items listed in the warrant. We caution you when you're dealing with these agents, do not volunteer information. Do not. Tell them very graciously, I'm sorry, but my lawyer will be very angry with me if I answer your questions. My lawyer insists that he or she be present if I'm going to be questioned in relation to this warrant. The agents will provide the employer with a list of items seized during the search. Important that that inventory be maintained. If some of the items to be seized are important to the operation of the business, let the agents know that you need to retain those in order to effectively operate the business. Sometimes they will let you keep it. Many times they will not. That's an issue to be taken up with counsel later to try to retrieve that information from the evidence files while the audit is ongoing.
Mary, there's a question here, which I think is important, and I can't remember if we were planning to touch on this or not, but so the question specifically is about a workplace that's under federal law protection and whether immigration will still come inside. So I would like to ask you to talk about sort of the policy, a previous policy of not visiting places that were, shelters, schools, etc., whether that policy is still in place. And then, the person who put this question in the chat, if that does not answer your question, let us know. But what is the view of the incoming administration about workplaces that might otherwise, might previously have been considered, safe?
Yeah, like churches.
Like churches.
Well, the previous administration did have that policy in place, but Mr. Homan has indicated an intent to terminate that policy on day one of the Trump administration, meaning that ICE is free to go anywhere where individuals are employed in the United States, pursuant to the Immigration Reform and Control Act. There are no sanctuaries, and there are no places which are off limits because that policy will have been lifted effective Monday at noon.
Okay. Another question in the chat, aren't there two types of documents that an ICE agent may present, one which we can outright refuse and one that we have to accept? So that's I don't know the answer to that question. Do you?
Well, if they're talking about the difference between a search warrant that's signed by a judge and lists areas of the immigration law that relate to crimes, such as the anti-harboring statute, bringing in more than 10 employees in a 12-month period for purposes who are known to be undocumented for purposes of employment. That's a crime. The government may have conducted surveillance on the worksite, electronic or otherwise, and have determined that the employer has violated that threshold, and may obtain a warrant from a magistrate judge or a Article 3 judge in a federal district court, generally with the assistance of a U.S. Assistant attorney. And if that search warrant is served, the employer must comply with that. There is such a thing as an administrative warrant that has been issued by a supervisor within ICE. That can be ignored because it is not backed by a judge. But if you ignore it, they will be back. If you're not prepared to deal with the execution of an administrative warrant on the day that it is served, then it's probably best to turn them away and say, no, thank you. Bring me a verified or a legitimate warrant and we will comply, but we will not be complying with an administrative subpoena.
Perfect. Mary, this next slide has a lot of tips. In the interest of time, we have about 15 minutes left. I'm just going to ask you if there are any points I think you've already covered a few of these points. Are there any points you want to highlight without going through all of them in the interest of time?
All right, and I won't. Please, and this is true in the restaurant industry particularly, do not tip off employees that ICE is there. Do not assist employees in evading ICE. If you do, you could be subjecting yourself to potential criminal prosecution for obstruction of justice or harboring. So that's important. But do be very cognizable that the people who work in your workplaces have families. Do ask the agents, if possible, to let them go. If they are not under suspicion, they should be allowed to leave the workplace and attend to their families. If they're going to be arrested, there's nothing that you can do about that, but make sure that it is being done in a humane way. But do not interfere with the officers in what they are doing. Follow them. Make sure that they are being humane. Use your cameras on your phones. If you think that they are being abusive or violating the rights of your employees, document it. So I think this slide speaks for itself, and since we are short of time and absent a question, I think that'll do it.
Okay. And then the next slide is related, and again, without going through every point, if you can just sort of highlight or summarize the rights that employees have while a raid is ongoing.
All right. Well, they have the right to remain silent. ICE is going to approach them and ask their name and their immigration status. They don't have to answer that question, but it's not up to you to tell them not to answer that question. Hopefully, you have had an attorney into the workplace who can address their concerns, talk to them about their rights before ICE would arrive on the scene, so that they know. But you should not be the one that is giving them this information, because if they volunteer that to ICE down the road when they're interrogated, my employer told me not to answer these questions, it could lead to problems for the employer.
What can an employer expect following a raid on the workplace?
Well, it's certainly not over at that point. There's, every defendant is concerned in the aftermath of the execution of a search warrant, if that is what has happened. But let's say that it's a notice of inspection that you have responded to. This is the raid. Well, certainly you want to be involved with counsel in trying to retrieve information that may have been taken. If you want to contest the warrant, then you have a limited amount of time in order to do that and work with counsel in doing that. If I-9s have been taken, down the road, the agents are going to be serving you with a notice of suspect documents. And to the extent that employees are still on the workforce at that time, you will have a limited amount of time in order to re-verify them and ask them to present different documents that are acceptable for identity and work eligibility. And then, of course, ultimately, there is a notice of intent to fine in a civil situation. A civil and a criminal investigation can proceed concurrently and frequently does. I'm not sure that if we need more information about that, but certainly we'd be happy to talk to anybody who has been the object of a raid.
Great. And just to reiterate, there was a question about, can we please have a recording of the webinar? So Christina, if you can confirm, I believe that in addition to the PowerPoint, we will be disseminating a recording of the webinar. We'll be making it available on our website. If I'm wrong, Christina, please correct me.
You are correct. We will share everything with everyone.
Thank you very much. So one question, Mary, before we have just a few more slides. This person says, our restaurants don't keep the documents physically on site. It's in our headquarters office. What would happen if we were raided and we don't have our documents in the location of the raid?
Well, ultimately, the warrant will extend to the employer. They're going to get the documents ultimately. And there are many restaurants, chain restaurants particularly, where they are retained at headquarters. We try not to expose the employer more than we have to. Hopefully the warrant is limited to one location and only the I-9s relating to that location would have to be produced. But in many instances, if the I-9 program is administered centrally at the headquarters, ICE will seek to look at all the I-9s of all of the restaurants of that employer, not just the location that was raided.
Okay. Let's turn to the slide. So other than I-9 audits and raids, which we've spoken about, what other immigration enforcement activity might we expect to see?
Well, we'll put this on the label, the business immigration side. We know that during the first Trump administration, he issued an executive order called the Hire American, Buy American, Hire American. And that executive order was used as a justification for stepping up fraud investigations involving L1 intracompany transferee visa holders and H-1B specialty worker visa holders. As you know, there's been a lot of controversy between Elon Musk and Steve Bannon on the airwaves about the H-1B program and whether or not it is being used to deny jobs to U.S. workers and suppress their wages. Well, one of the ways that they're going to try to prove that is to visit the work sites that are set out in the H-1B petitions filed by employers and the L1 petitions filed by employers to question the beneficiary as to whether or not they are performing work which is within the four corners of the approved petition, that they're being paid as they should be paid, and that they are not underclassified in terms of the skill and the occupational need that they are filling. If they find that the employer is uncooperative or that the information is not consistent with their standards for maintaining H status, the next step is to issue a notice of revocation. Again, it's a civil procedure served on the employer to revoke the status of that particular employee. And we have seen a lot of these FDNS inspections. Frequently, that's the fraud detection and national security unit of the Immigration Service. And frequently they come in the company of wage and hour investigators from the Department of Labor, who enforce the labor condition certification requirements that all H-1B employers have to attest to.
Sorry, I advanced a little quickly. Okay, so I think we've covered this pretty well. So how should employers prepare for potential site visits? In this case, we're talking about for H-1B workers. So having an action plan in place for each work location and the employer's H-1B petitions. I'm going to move to the final slide here, which is what advice would you give to employers who place L1 and H-1B workers at third-party work sites?
Well, these work sites used to be a secret, and FD&S had difficulty identifying where they could go to conduct a fraud investigation. No more. That's because the labor condition application itself and the visa petition contain the work address where the individual is supposed to be working. And frequently they are third-party work sites. If you are the petitioning employer and you have a contract to place workers at a third-party work site, it behooves you to have a discussion at the time of contract or sometime thereafter with the counsel of that client to develop a common action plan for how to respond to these worksite investigations. The worksite employer itself has never signed consent or given consent for entry to the private places of its business. So ICE can't do that, absent having a search warrant signed by a judge, which is another kettle of fish altogether. But they can't come onto the worksite of a third party without the consent of that third party. On the other hand, if they don't get the consent and they can't talk to the beneficiary to confirm the terms and conditions under which he is working, then a revocation could proceed. The best way to handle this is to educate your clients, to get their cooperation in permitting FD&S to conduct a private conversation with those workers at a public location, perhaps a conference room that's not in the private areas of the business. Don't let them be wandering around. But that is the best recommendation that we can give to clients who are staffing companies with H-1B workers being placed at third-party work sites.
Okay, thank you, Mary. So there are two questions in the chat that I'm going to address, and then I do believe that Sean Townsend from the Restaurant Association is here, so we're going to ask him to say a few words in conclusion, but I just wanted to address these questions about conducting an internal I-9 audit. So if you are conducting an internal audit and you find an error that can be corrected, we do recommend that you initial and date it in a color of ink that's, that makes it clear that it is a correction. Another question, are employers supposed to keep copies of the documents used to complete the I-9? And I think the answer, Mary, that we always give is you should either keep them for everybody or not keep them for everybody. I don't know if you have a preference, Mary, in terms of keeping them or not keeping them, but the most important principle is to be consistent.
Yes, to be consistent. In the old days, the criminal defense lawyers would say, oh, get rid of that information. Well, yes and no. If you have a substantive error in section 2 of the I-9, wherein you have failed to accurately record the documents in the right places that are on the list of acceptable documents, having a photocopy of the document that you reviewed will relieve you of that substantive violation. So, this is a case-by-case call best made in consultation with a lawyer as to whether or not you should keep or not keep your I-9 documents. But in many instances, those who have kept them, we've argued that it is evidence of good faith of the employer in complying with the law, and it has cured substantive violations that would otherwise be charged against the employer.
All right. Thank you so much, Mary. So as mentioned, we will be distributing a recording and a copy of the PowerPoint. This webinar is co-sponsored by the Restaurant Association of Metropolitan Washington. And Sean, if you would like to wrap up our webinar, we would love to turn it over to you.
Good morning for 4 more minutes. Sorry, I'm late to the party. But thank you all for joining us today, and special thanks to Grossman and Mary and Becki, of course, for sharing your expertise on a very important but also timely topic. We learned that staying ahead of compliance is important, especially for and in terms of protecting your business and your teams. We heard some very helpful tips today, with enforcement likely to increase, in the next couple of days. Preparation and really just being proactive is key. Of course, we're here to support with resources and connecting the dots and advocating on behalf of our members. So if you have questions, feel free to reach out to RMW or to Grossman directly. And once again, I want to thank everyone for joining. Thank you, Mary and Becki, for driving this plane today. And I look forward to seeing everybody soon.
All right. Thanks, everybody. If you're in Washington, D.C., stay warm and stay safe this weekend, and probably stay out of the downtown area because there's a lot of road closures for the inauguration.
That's right.
All right. Take care, everybody. Thank you.